Okay, good morning, everybody. I think we're live. It's just on 11. We're just watching everybody come into the waiting room. This is a really busy session. We've got lots to cover and we've got loads of people joining. So we'll just make sure we can get as many people as possible before we start. So I'll just give it a minute, but we can't wait too long because there's lots to cover, isn't there, Cilla and Lauren? So I'll just watch the numbers go up.
There is indeed.
Hello to everyone joining. Sorry, Cilla.
I was just saying, yes, there is indeed a lot to cover.
Lot to cover. Mel, we've just had Firefly AI join. Can you take them out? Thank you. Cilla, they record. It records, so we don't want that. Right. Okay. Thanks, Mel. Hi, everyone joining. Okay, I can see the numbers still climbing, but let's get started. Good morning and thank you for joining us again for our HR horrors and employment law update. It's a really busy session, but thank you again to Cilla Robinson and Lauren Cooper from King and Wood Mallesons. I would like to acknowledge the traditional custodians of the various lands on which we work today and pay respect to our elders past, present and emerging, and extend that respect to First Nations people joining us today from wherever you are. A brief introduction from myself. I'm Angela Franks, the partner for Fraser Jones here in Australia. We're a global HR, recruitment and search business operating across the whole spectrum of HR or people and culture. It's been quite a mixed year for recruitment in the HR space. We've been doing a lot of retained search and quite niche searches this year, along with some of the usual work that we do. But I know that there's a lot of people in market looking and a lot of clients looking for quite niche skill sets. So if you're thinking about a move or hiring for your team and want to understand some of the trends or need to partner with somebody, please do get in touch. We are having... So actually, for anyone who's been tuning into these webinars for a while, you know that Cilla's updates, Cilla and Lauren's updates happen twice a year, and they're always well attended and a lot to get through. But we're actually going to squeeze in 2 more events before the end of the year. So on the 18th of November, I've got John Baker, who's a known name in the HR recruitment space, who's presenting online talking about how to craft an executive resume and elevating your profile, especially in a tough market. So watch out for that. And then on the 1st of December, we're going to have an open coffee morning for the senior talent acquisition professionals available and looking in the market. I've not done one of those before, so we'll see how that goes. I might get 10 people turn up, I might get 100, but anyway. So look, if you want to keep an eye on our website or follow me on LinkedIn, I'll be sharing some of those details down the track. So moving on to why we're all here today. So always, again, really appreciative to Cilla and Lauren for hosting these. Cilla, I think you've now done 25 years, have you? Maybe even longer in the employment law space. So congrats on that.
I thought you were going to say 25
milestone.
years of HR horrors. Yes, thank you. Nudge, it'll be 25 years in December.
Yeah, there we go. So close. Okay, fab. And thank you, Lauren, for joining us. Lauren's a senior associate at KWM, working really closely with Cilla in the employment relations, employment and safety space. So over to you, Cilla. I think we've got quite a lot to get through. I'll go on mute. I'll monitor the chat. Last time it was difficult to get through all the questions, so I'll do my best, and we'll see how we go for time. Thank you.
Thanks so much, Angela, and thanks everybody for tuning in. So in terms of what we're going to cover today, broadly, we have 5 topics: union action, workforce transformation, Fair Work Ombudsman activity, safety regulator, safe work activity, and then we have the latest horror stories. So look, there have been lots of big cases this year, and many of the cases we'll be talking about today, you would have read about in the media, heard about. We will be unpacking those cases today with a real HR lens. We will be unpacking them in a different way than we would if we were talking to a bunch of lawyers. But you would all be aware that there is a lot happening in the world for us HR and employment law folk. And I think these employment and HR matters are capturing headlines in media to a degree that we've never seen before. So that's great for all of us. What we do is important. It's getting headlines, but it is creating a lot of uncertainty and creating a lot of havoc for all of us in our day jobs. So Today isn't a classic HR horrors with lots of juicy fun facts and crazy cases like we've had in previous years. We are going to be talking about some big ticket items that do create a living nightmare for many of us HR professionals and employment lawyers alike. So I just wanted to give that qualification up front. There will be some legitimate HR horrors at the back end of the session. So, look, the first one that we wanted to talk about really relates to union activity and what we see as a changed industrial landscape. And so, this case is TW and Qantas. I think, unless you've been either overseas or in a coma for the last several years, you would have already heard about this case. Hopefully, that doesn't apply to anyone on this call. So, look, as per usual, we've included a decent amount of content in the slides. Angela and Fraser Jones will send out the slide pack to all of you. So we've got a lot of content in the slides so that you can revisit it afterwards. I'm not proposing to go into a crazy amount of detail on the fact set because, as I said, lots of these cases are really relevant to you all because of the implications rather than the specifics of the case. But in terms of a very quick recap of what this case is about, you'll all recall that during the pandemic, there were travel restrictions. As a result of that, Qantas wasn't flying its planes. There was a 91% profit reduction of Qantas. And as a result of that, they were, of course, looking at means to regain those profit lines. And in 2020, there was a 3-year plan that was announced. And part of that plan looked at outsourcing the ground handling services. And the net take out of that was that there would be probably about $100 million cost saving per annum, and Qantas wouldn't have to spend about $80 million on capital expenditure that it would have had to undertake over a 5-year period had it retained its employee ground services employees. So this is the timeline. You know, it started in 2020, it ended in 2025. The key takeout of this was that in the context of considering outsourcing baggage handling, an enterprise agreement that impacted these baggage handlers was up for renegotiation. And in this case, the Transport Workers Union asserted that as a result of these employees being outsourced, they lost the opportunity to engage in bargaining, to engage in protected industrial action, and essentially that they lost that ability to exercise those workplace rights. And most of you would be aware in this country, these industrial rights of being able to bargain are sacrosanct in terms of the union movement. And so the backdrop of enterprise bargaining meant that the timing of the decision to outsource this part of the Qantas workforce was under real scrutiny. So most of you would be aware that in general protections or adverse action claims, there is a reverse onus of proof. So in this case, Qantas had to prove that the decision to outsource baggage handling wasn't in response to these employees' ability and right to exercise their workplace right to bargain and or take industrial action. And most relevantly to all of you, in the case, there was, of course, analysis about why the decision was made to outsource. That, of course, brought in the decision makers, and most of you would be aware of that is a challenge in these cases in terms of what are the subjective beliefs of the decision maker. But here, of course, as with all litigation, there was also discovery of all documents that really supported those decisions. And essentially, some of that documentary evidence called into question whether the driver for the outsourcing was purely the cost savings of that 3-year cost reduction plan. And it queried whether perhaps that background of the industrial disputation and the renewal of that enterprise agreement was actually a reason why these people were being terminated. And so I think probably one of the things to think about when you're making these decisions or involved in these decisions is who is the decision maker? Can they be quarantined in a way so that the broader backdrop or factual matrix that might be relevant but isn't really the true reason for the decision can be separated? So, look, that's the backdrop to this case. But the real reason why this case got such a lot of attention was the penalty that the federal court awarded in this case. And when considering penalties, the things that are on this slide is what a court will consider. So requirements of deterrence, that's, specific deterrence and general deterrence. So again, is our penalty going to have a general deterrence in terms of the broader marketplace? The number of contraventions and the maximum penalty are also considered here. The number of contraventions in terms of the adverse action that was taken was 1,820, the number of staff that were impacted. And the maximum penalty that could have been awarded was 121 million, roughly, give or take a couple of hundred grand. And so there are some factors that the court had to consider. Of course, the nature and the circumstances of the conduct is also considered. I mentioned before that industrial rights and bargaining are really hallowed rights in terms of Australia and how we view these things. So that was relevant. The circumstances and character of the contravener here, that's Qantas. Of course, the size and scale of the organisation is relevant. The fact that they had a law firm representing them. And then other circumstances are relevant as well. And namely here, things like adverse media attention were relevant. So we would all be aware that Qantas is a big target, but the flow-on effects of this case are really relevant to all of us in terms of people that work for employers and work in the HR space. So for those of you who were living under a rock, it was $90 million penalty that was ordered. But the staggering part about this decision was that $50 million of that penalty went to the Transport Workers Union. And this really was a watershed moment for the industry, and it was a really significant change. Now, why did the court do that? The main points are on the slide. The union was solely responsible for pursuing the litigation, and that is because the government and the Fair Work Ombudsman didn't do anything. So the judge found that the union played a significant role in exposing this breach by the employer. Of course, coming up against a big organisation like Qantas, it was a very onerous and burdensome piece of litigation to take on. Created risk, of course, to the union in terms of their funding base, and significant resources, of course, were deployed to fight the case. So this is the main reasons why the union was awarded $50 million. The main takeout of this is that this case has really incentivized unions to pursue similar actions, in particular against powerful employers where they've got deep pockets. And in terms of putting that 50 million in context, that's probably about 25 years worth of union dues that the TWU now doesn't need to get because they've got that money there. And so they are cashed up. So of course the TWU is very active, and we're seeing that. But lots of different unions are talking to us and talking to our clients about looking for class action opportunities within big workforces. So that means that when you have the same set of facts for a number of different people, there is now a class action risk that the unions might take on rather than the historic class action law firms like, the Shine Lawyers and the Morris Blackburns of the world. So these types of matters can actually be massive money spinners for the unions, plural. So that does naturally create a risk for employers in terms of any contraventions being pursued at scale. So why was the penalty so high? This slide includes the reasons that Justice Lee talked to. So, of course, the need for deterrence to send a strong message to the marketplace that we shouldn't do these things. There are a number of fact-specific circumstances that are relevant as well. I think probably the main one for you all to focus on is the size of Qantas cost savings. And really what that bottom slide talks to is that sometimes when we make decisions to outsource, or really make any decision within business, there can be an assessment internally of, okay, well, we can do this. What are the legal risks? What potential penalties might arise? And here, because Qantas was going to save $100 million per annum, a $90 million penalty was, in the scheme of things, could be described as just the cost of doing business. So I think we just need to be very careful about the documented materials that support these decisions. So there's not a perception that a company is knowingly contravening the laws or knowingly making decisions that they think might be wrong. And I'm not suggesting that that's what Qantas was doing, but that's the outtake, where essentially there is this cost assessment of potential penalties versus potential benefit. So it is a really relevant one to consider in terms of when we have file notes of decisions, and what they say. Could they be misconstrued in a problematic way? So here again, consideration of the penalties. These are again quite fact specific, but the fact that Qantas obviously had their lawyers working. There was a deliberate process that was undertaken, um, and that essentially there was some problematic documents in discovery were relevant here. I think from your perspective, the main takeout is, can we have parallel streams for decision makers, so that we can try, as I mentioned earlier, to quarantine the decision maker from a broader fact set where it could be misconstrued by a union, or employees may have a misapprehension where they're essentially getting the wrong end of the stick as to why we are making that decision. But the strong thing that I want you to all reflect on is that this is showing that the federal court is taking a really hard-nosed approach to compliance when it comes to big business and strict compliance. And I think that's a really relevant thing for us to reflect on when we're making these decisions that impact on employees. So we'll move on now to Helensburgh Coal, which Lauren will take you through.
Thanks, Cilla. So for the second case today, obviously we'd be thinking, why does this High Court decision matter? It's probably less reported than some of the other decisions that we'll be speaking through today. And on that note, I did want to take you through a bit more of the granular detail, because unlike some of the other decisions that we will be talking to, this one relates to workforce transformation. So that's no doubt genuinely what you deal with on a day-to-day basis when you're working within your businesses, trying to understand what the restructuring looks like and how it can be undertaken. So on that note, we'll switch to the next slide there, Sil. Thinking, why does this High Court decision matter? Well, it actually obviously genuinely impacts the work that you are doing as HR professionals. So we will take you through some of this background. So as with the Qantas decision, we've got similar fact circumstances in that the organisation, Helensburgh Coal, was having a look during the pandemic as to how it can drop numbers. There was obviously a significant drop in demand for coal production, which no doubt then resulted in some decisions needing to be made around resourcing within the organisation. So like a lot of organizations during the COVID-19 pandemic, they led to reorganization essentially that reduced its workforce by 90 employees, and also relevantly, its contractors by 40%. There was still some work though being undertaken by contractors after they let the employees go. Following the dismissals, there were 22 unfair dismissal claims that were brought, and ultimately those were bundled and heard together in the commission. So for the unfair dismissal remedy, as you can appreciate, that's quite a high proportion of those dismissed employees that ended up bringing a claim against their former employer. No doubt, Helensburgh obviously objected on the basis that the dismissals were a result of genuine redundancy. So I'll take you through some of those primary issues in terms of what constitutes a genuine redundancy. So from about 2009, there was a carve-out included from the unfair dismissal regime, which essentially results in where things are considered a genuine redundancy, they're not captured under the unfair dismissal regime. So they're dealt with separately, and we often put on a jurisdictional objection when those types of claims come in. So you're no doubt aware of these, this case essentially just from a high level and those elements for genuine redundancy. So I want to take you through just at a high level that it also requires the employer or your organisations to have a look and make sure that we're fitting in with whatever consultation mechanisms and obligations exist within your workforce. And relevantly, this second element here, that it's not reasonable in all of the circumstances for the person to be redeployed within your organisation, and also relevantly that of an associated entity. So the second element there, obviously it requires those additional considerations, and the court essentially, or the commission, was entitled to have regard to the workers performing the work within the organisation and also the enterprises or associated entities that fit within your group or the umbrella that you operate in. So it's whether to determine whether it would be reasonable for an employer to remove existing positions from their roles or otherwise restructure the operations in order to create available positions into which the redundant employee might be redeployed. So as you can appreciate, that has quite significant ripple effects where you've got an existing workforce, and previously, before this High Court decision, what we would really be doing is almost, and we've had a lot of clients fall into this, to say, look, well, there's no vacant roles within the organisation, so it's almost that tick the box in terms of, no, there's no redeployment opportunities to see here, and you often go forward to the employee and say, we haven't identified any redeployment opportunities, so therefore there's no redeployment. However, if you identify any roles, you let us know, and it fits within that consultation process. Now, this has significantly shifted the dial in terms of that obligation on organisations to have a look within its existing enterprise, associated entities, to identify those roles that might be able to be reshuffled or made available to stop someone's role being made redundant. So on this High Court decision, essentially the High Court dismissed the appeal and affirmed the decisions of the previous Fair Work Commission hearings and also the full federal court decision. So the federal court then held that the Fair Work Commission has the authority to consider all relevant circumstances, including operational and workforce arrangements, in determining whether a dismissal is a genuine redundancy. So that's obviously significant for our roles. I'll move on to the next slide because we have covered that last point there, just around having to consider the vacancies that exist within the organisation, but also how things could be restructured to create those roles. The only limitation on that, again, which I'll highlight, is that it still has to be reasonable in all of the circumstances. So what that means within your organisations will be fact-specific and obviously depend on the various roles, how many people we're making redundant, and what the obligations are in terms of the size of the workforce, including those contractors which may be around. So it's led to essentially a material expansion of what the Fair Work Commission powers of inquiry can entail. And we see that this might drive union activity in this space, in that they might more actively go to pursue litigious challenges on organisational change, which in the past hasn't been a focus for unions, where it's only been 1 or 2 employees and the jurisdictional objections are made. This is quite a big decision for that type of claim and area. So the first key impact on there, which I've talked through, is the higher bar for genuine redundancy. So it's really elevated that consideration that we have to give in terms of when we are determining which roles are no longer remaining in a business when we undertake that restructuring activity. We've got to apply that lens of understanding what the people do, what roles exist around them, including casuals, including contractor workforces. So that leads to the second point there around reviewing contractor arrangements. So we've got that essentially high a bar to consider what other roles exist and where it might be reasonable to let other roles go or restructure certain roles to keep people employed. That is essentially what now might be required of an organisation, or if you were defending a claim, you might need to have considered that and documented steps relating to those roles. There could be other cases relating to offshoring of work, in that if we offshore certain work, the Fair Work Commission might determine that that wasn't reasonable to let certain roles go. So you can understand that there are a plethora of different cases and ripple effects that might come out of this High Court decision, as it was the first of its kind, considering the redeployment limb of that genuine redundancy test that we are all familiar with. So it goes without saying, like with all HR processes, keeping really clear documentation of these steps that we're taking, understanding which decisions are being made or where things are, might have been considered to be reasonable, but why they might not work for the organisation. That's going to be critical in meeting that higher standard, and also being able to defend claims if they are made. And the last point there on this slide is greater consultation. And whilst this genuine redundancy and the reasonableness is part of the limb within which we consider which roles are no longer existing in the organisation, it does elevate that bar of understanding, well, redeployment opportunities would be greater enhanced as well by having that consultation process and having it as a two-way, enhanced and more robust process with employees to try and get them on board and understand how those decisions are being made, and that, of course, they're reasonable in the circumstances. So on that note, I will hand back over to Cilla for some Fair Work Ombudsman content.
Thanks, Lauren. And look, I think really the impact of the Helensburgh coal case really does shape the foundation of some of the HR decisions that we make. So use of contractors, quite often we get contractors in because we've got headcount concerns. Ultimately, if the Fair Work Commission is going to be then looking into these decisions, then, the same job, same pay legislation, where labour hire staff can be getting paid the same as permanent employees, coupled with this, really is starting to create a landscape where really the benefits of having either contractors or labour hire are significantly reduced. So obviously that's the union and the Labor government's objective is to have more permanent employees. But I think this case really does affirm that analysis, and really, I think from an HR perspective, again, when these decisions are being made, it's incumbent on you to say, well, why do we want a contractor? Maybe we're going to have to, terminate them in the context of a redundancy of a permanent employee, or why do we want labour hire? We may have to pay them the same as an employee in the context of same job, same pay. So I think it is one of those ones that isn't just sort of an issue for the lawyers. It does just impact, I think, on the day-to-day existence of HR professionals as well. But as Lauren mentioned, the next case relates to the FWO, the Fair Work Ombudsman, and again, it's a case you will have read about in the media, the Coles and Woolies underpayment case. Now, I appreciate that you are not finance and you're not legal, and we'll try not to bore you to death. You guys dying in HR horrors is not the kind of horror that we look for, despite liking to have our spooky themes. But this is really relevant to you all in your day-to-day work as well. So again, I'm not going to go into the fact set in a detailed manner. There were allegations of underpayment. The Fair Work Ombudsman was looking into it. The key relevant factor is that the underpayments largely arose in the context of annualised salaries, which were insufficient to cover the overtime that the employees were working. And so this isn't a novel context for any of us. People are having annualised salaries. Those entitlements that might exist under an enterprise agreement award are rolled up, and the assumption is that that salary will cover any entitlements that the employee would have otherwise received. And so quite often we see annualised salaries coupled with set-off clauses in employment contracts. And essentially the effect is that the employee is saying, I'm going to pay you more, that additional payment above your minimum entitlements under the award isn't satisfaction in relation to instruments that would otherwise apply to your employment and entitlements that you would have, whether it's OT, penalties, allowances, and the like. And so we, in the employment law context, of course, refer to these set-off arrangements quite often, and it is essentially just a way to easily give the employee one payment in lieu of both their salary and the range of different entitlements that they might otherwise have under an industrial instrument or enterprise agreement. Now, importantly, this case sends a message about the time frame that we can assess the satisfaction of those entitlements, and specifically whether we can satisfy those obligations, over more than one pay period. So these are the findings of Justice Perham. Essentially, Justice Perham found that the set-off arrangements in the retailers' contracts were unable to discharge obligations under the General Retail Award for more than a single pay period. And so essentially the set-off arrangements couldn't apply for 6 months, 12 months, in whatever time frame you might all have. You could only look at a single pay period. So this is quite significant, because the impact of this means that we need to be doing that calibration of whether we are paying people for a single pay period, not over a broader amount of time. And as many of you all know, the benefits of an annualised salary and set of arrangements are that you might have peaks and troughs, but that overall, over a period of time, it nets out. This decision is turning that lens on its head. And so whilst we are dealing with some of the biggest employers in our country, this case is relevant to any employer that has these arrangements in place. And so most employers have modern awards that underpin the entitlements of their employees, and many do have annualised salary arrangements in place and set off. So it's a really important one to understand. So this slide talks to the key issues that were identified in the Fair Work Ombudsman proceedings. So, of course, we have contractual set-off. There was a reliance on the set-off beyond a period that ultimately Justice Perham found was appropriate. We had a challenge of record keeping in terms of being able to disprove the assertion of the employees and the regulator in relation to how much OT was worked by the employees. Again, an issue is that we need to have those records in place. They also need to be accessible. So it's not for the employee to justify the overtime. The employer needs to have those records of case to discharge its own obligations in terms of record keeping obligations at law. And then again, the key issues that this throws up is just advice on award questions. It used to be, 15, 20 years ago that HR professionals and employment lawyers knew these awards back to front because you needed to understand those entitlements. But with annualised salary arrangements set off becoming commonplace, quite often HR in particular are less familiar with the granular detail of award just because they haven't needed to, because the salary will essentially discharge those obligations in one go. So again, why do you care? Generally, this is a wage compliance issue. It might be payroll and lawyers working together with finance. But our HR clients are also getting pulled into this when it comes to the questions of, well how do we know what overtime the employees are working? Is there any ability for us to unpack their salary so that we can see what salary, what's relating to allowances, what is relating to penalties and OT? So in terms of the lessons of this, of course, as a compliance warning, we need to ensure that our salaries are sufficient to discharge the obligations under the modern award or enterprise agreement. I mean, that sounds like the most ridiculous motherhood statement, but you will all be aware that sometimes it's a little bit loosey-goosey, or we're picking, we have a really busy period in Christmas, a quiet period, in January or February. Essentially, we can't then balance those two out and be aligned with what is required now under these laws because of the extension of that period going beyond one pay period. So really important that we can't have set and forget arrangements in place anymore when we have these annualized salaries. And some clients have said to me, but what if we just pay them heaps more? We've got a great buffer. Well, that's going to be a very, very good start. But we also need to review our pay practices just so that we can meaningfully understand what pay relates to what things. So quite often you see quite general set of clauses that just say your salary is in lieu of any entitlements under the award. What we need to see now is specificity about overtime, penalties, allowances, anything that could result in a payment needs to be expressly stated so that you've got that specifics. That we need to remove any ambiguity in those contractual clauses so that we can see each entitlement that is being offset, so that we can verify um, those entitlements and what we're paying them against the actual work patterns. So that verification piece, I think, is probably the most relevant one from an HR professional's capacity, because we might be asking people to log time. We might have, tap on, tap off ways to record. Does that actually reflect the hours that people are working? What if they're working from home? How on earth are we going to cover that? So it really is something that you need to be aware of. I mentioned record keeping. Do we have contemporaneous notes so that we can disprove if an employee says, hey, on the weekend I worked, 80 hours of OT? How can employer disprove that? And of course, ideally, we have audit arrangements so that we can again shore up our record keeping obligations and verify what we're doing so that we're discharging our obligations both to our employees in terms of what they're being paid, but also to the regulator to the extent that these things come under question. Very speedy analysis of that case. Hopefully everybody's still alive. We didn't bore you to death. This next slide relates to Safe Work, our safety regulator. And Lauren has mentioned restructures already. And look, I appreciate the wage compliance and safety compliance are probably generally, HR horrors to all of you. But I think this one is probably one that is really relevant to the day-to-day for pretty much everyone that's online here. So the backdrop of this matter that we wanted to talk about was in relation to the University of Technology Sydney, and UTS launched in 2023 an operational sustainability initiative, essentially a cost-saving initiative where they wanted to reduce cost by $100 million. Again, pretty vanilla circumstance. There was a plan. It included the job cuts of 400 people. So that was 2023. So that was a plan that people are all aware of. Then fast forward to 2025, and the consultation process for this restructure starts. So bear in mind that people have been aware that jobs were to go for some time. We all know that that's stressful enough. Then what we saw is 1 day's notice of a consultation meeting where employees were invited to attend a meeting in relation to their employment. And all of us know, again, that's not uncommon. Quite often you do have a day's notice. And really there's a decision about balancing. You don't want to give someone too much notice, then they're going to be stressing about the fact that they've got a meeting in 2 weeks about their employment. So there's a real balancing act in that decision of the timing. But here, what we had was union engagement. We had a union survey of the staff, which said that they were very stressed by this process. That survey was provided to Safe Work, and Safe Work took an unprecedented step in issuing a prohibition notice to UTS. And what that meant was that the restructure process was stalled due to serious and imminent risk of psychological harm. And UTS was ordered to consult with staff and assess the psychosocial risks of that restructure process before proceeding with it. Ultimately, the prohibition notice was lifted after that engagement had occurred, but it was a really, really novel thing to see the safety regulator inserting itself into that process because there were these risks of psychosocial harm to the employees. So as I mentioned, it was the first prohibition notice of this nature, just in a vanilla redundancy process. There was a lot of media about it, and some of the facts that here talk to the specific risks and circumstances that are relevant to the higher education tertiary sector. But I think everybody that's outside of that sector also needs to have regard to this, because restructures are inherently stressful processes. Now we really need to be having bespoke risk assessments for the restructures themselves. That is a way for us to discharge our work health and safety obligations in terms of the psychosocial hazard that these processes may incur. Now, I mentioned the broader landscape for the universities. And Macquarie University had a improvement notice issued to it after after the UTS event, where again the regulator was asking for information in relation to restructures. Where they were seeking to reduce 50 or 60 roles. And so what we're seeing is that the regulator is really taking an interest in these things. Restructures are a known psychosocial hazard. It's in the model code of the safety regulator, but this interest in how these things are unfolding is new, and it means that we need to be very careful when we are undertaking these processes within our organisations. So the takeout for all of you, as I mentioned, review and update the psychosocial risk systems that you have. Are you thinking about restructures in the control mechanisms and your safety plans to ensure that the organisation, directors and otherwise, are discharging their work health and safety duties? Of course, as I mentioned before, working from home can increase the risks as well. So we should be looking at these risks in an ongoing and continuous manner. Again, risk assessments for the specific change management processes. Now, we're talking about restructures here, but similarly, the introduction of AI or the introduction of some other workplace change might be similarly stressful and might have similar psychosocial risks for employees. So I don't want you to think that we're just limiting this to restructures, despite that being the context that these certain cases came up. Again, strengthening communications with staff to try to minimise the stress of the employees. Ultimately, UTS was criticised for having only 1 day notice, but as I mentioned, the counterfactual to that is you give someone too much notice, they develop a stress condition because they're waiting for the answer. Am I going to be fired? Am I not? It is important that we also think about the context here, broader issues, safety issues on campus, geopolitical scenarios that are playing out on campus, increased stress, academic freedom disputes, reduces in funding cuts. All of these things were relevant because the workforces at these universities were already stressed. So for you all, think about the circumstances of your company, of your sector that might be upping the ante on stress generally of the employees, and provide tailored support. There was some material given to the employees at UTS, which talked about things to reduce their stress, like brushing their teeth or eating cake or washing their delicates. And ultimately, these things were seen to trivialize the seriousness. Me eating cake, it's going to help a little bit if I'm being fired or think I'm going to be made redundant. Brushing my teeth, washing delicates, it trivialised the impact of this change on the employee. So these are things that we want you to be thinking about going forward when you're undertaking these workforce change scenarios within your workplace. Now, Lauren's going to talk about some recent horrors and headlines.
Thanks, Cilla. So we've talked about AI on a number of different and previous presentations with Angela and Fraser Jones. So we won't recap on that, but I did want to say that it continues to be a horror for many organisations. Our clients are coming up against challenges with AI almost on a weekly basis. The most recent one, obviously, which was all over the headlines, is this Deloitte report that was prepared with the assistance of AI, and they've actually had to pay back in part some money to the government in respect of that report. So I won't go into that in any more detail, but I did want to show that it's continuously coming up, and there have been multiple challenges coming out of the way in which our employees in the organisations are using AI, and no doubt it's coming across your desks too. In our space, so shifting it into the employment claims space, there's been a real surge of matters in the Fair Work Commission relating to, say, unfair dismissals and general protections claims. And the president of the Fair Work Commission actually has commented on this significant rise, and in particular on general protections claims where 80% or 4 out of 5 claims are not proceeding to court after they fail to conciliate at the Fair Work conciliation stage, which is quite astounding when I saw that those statistics come through recently in the media. So obviously there's a lot of claims being brought with the view of hopefully trying to settle or drawing money out of organisations without any intent for those general protections claims to actually go through to court. Interestingly on this, and the link why I raised it for AI, is that the Australian Council of Trade Unions expressed that they think that the rise in claims is directly related or linked to artificial intelligence and the use by applicants in preparing the claims or understanding the laws to be able to formulate their arguments. And we've certainly seen quite a few legal documents and responses in investigation processes or even in consultation around safety matters or dismissals, where applicants or employees are using AI or ChatGPT to help formulate issues and come forward with their points of view. And often I'm led, speaking to clients to try and navigate what the employee is either trying to say. On the other end, we've had AI used in a consultation process. We were really trying to and struggling to understand what the employee's critical concerns were because there was too many things happening all at once. And the AI had almost collated it into a particular way that led the organisation and the HSRs in particular to come to a meeting fully prepared and able to articulate their key concerns that could be then addressed by this particular organisation. So whilst it's a horror, I do think that it is leading to some quite interesting ways in our matters and how things are unfolding, and no doubt will continue to be topical in this HR space. So on that note, I'll hand over to Cilla to share some more horrors.
Thanks. So look, this is our last substantive slide. We want to ensure that we have some time for questions. And picking these horrors is always a fun but challenging task for us. But I think, as Lauren said, AI, it's a conversation that we get calls about all the time. Similarly, work from home. And this is just part of the modern workplace, right? But you can see from the headlines that are on the slide, there are real challenges. And I mean, I think we all accept that work from home is here to stay post-pandemic. Organisations are not going to be able to wind back to 5 days in the office that many of us used to. And if employers do try that, quite often they get employees working with their feet, in particular the younger generations who are more insistent on their workplace rights and the desire to have that flexibility. But of course, it's not just younger folk and it's not just women that want to work from home. Everybody, in my experience, likes to have that flexibility and to have those options. So look, some of the things to consider, though, that are coming up as horrors is we've got people working from home. How do we actually ensure that people are working productively? How do we make sure that people aren't just taking the piss and watching Netflix when they're at home? And so that then brings us to, can we use AI for workplace surveillance? Seems like a decent idea. Keystroke monitoring, all types of different things can be deployed. However, AI surveillance is a real source of stress for employees. And there's been quite a lot of research about that. And the TW and other organisations, the ACTU, have been agitating about AI being used as part of workplace surveillance creates a psychosocial hazard. So we need to be really careful about using AI and workplace surveillance generally, because that can create stress. And so it's not just that It creates stress, but quite often that can lead to retention issues so that people don't like that big brother monitoring and vote with their feet. So we need to grapple with productivity and profits on the one hand, employee psychosocial wellbeing on the other hand, you HR folk and us employment lawyers right in the middle of that. So again, that's a challenge. Similarly, how do we pay people? People are working from home. If I'm working from home, I might stop work, go and have dinner with my family, log back on later, work until the wee hours of the night because during the day I was putting the washing out as well. But in a world where people are entitled to award payments, we're clicking into overtime, we're clicking into penalty rates. So there's been a real discussion amongst business and unions about how we look at that. And business is pushing towards those penalty rates being removed in relation to work from home scenarios. And of course, the unions and employee advocates are pushing for those entitlements not to be removed because it then can create this this decision that then means that employers can take advantage of people and just expect them to work around the clock when they're working from home. And then, of course, we have requests for flexible work arrangements and specifically work from home. And I think the main thing to really understand is that when you're assessing these requests, you need to, of course, think about the reasonable business grounds on which to reject a request. Now, if someone's been working from home for many years, that might be a challenge. An employer can only refuse a request if the employee's discussed it with the employee, genuinely tried to reach an agreement with the employee, and the employers have regard to all the circumstances for the refusal, and the refusal is on reasonable business grounds. Now, I really encourage you to be thinking about this when the business says to you, we can't have this person working from home. Think about it from the lens of, if not, why not? Can we justify it? Can we justify it for that specific role? And I really encourage you to have that granular discussion, because this is the only means by which you can defend a decision where you say, no, you can't work from home. And so similarly, if you are thinking about litigating these claims or defending a claim that might be in the Fair Work Commission, think about, is this the best case? Do we have the best factual scenario to resist the claim in court? Or might this be one that we let go through the keeper, have a settlement with the employee, or come up to, an amicable resolution if it's not going to be the best case to test that threshold in court. Now, again, quite often we talk about the benefits of social interactions in workplaces. We need to think about the specifics. Why does this role need to have in-office connectivity, rather than making just sort of broad sweeping statements that, of course, it's great for everyone to get together in the office and that builds trust. I'm not suggesting that that's not the case, but these are some of the things that the Fair Work Commission has been critiquing. So look, it's a new normal. Working from home is here to stay. We are expecting to see 4-day work weeks feature in bargaining claims from unions. The unions are really going to be pushing workplace flexibility and working from home arrangements, whilst also resisting AI. So there's a lot that we need to unpack, and the sooner we can get employers on board with this to accept that this is the new normal, the better, because it's really up to us to balance productivity and profits, happy workforces. We're right in the middle of that in terms of the war for talent, engaging staff, keeping staff in play. But we need to not see it as this binary decision where it's profits versus people, and find a way so that we can navigate things that ultimately result in both the employer and the employee being happy. But with that, and as per usual, over time, we've got 6 minutes for questions. We're happy to stay on a little bit longer if people want to. But I'll hand over you, Ange, to
Thank you.
to take questions. Did you want me to stop the share screen if you've got a different slide to pop up, or?
No, that's okay at the
you?
moment. No, that's all fine.
Okay.
Have
No
you
worries.
had a chance to quickly look at the questions? There's one in the Q&A and one in the chat. Helen asked, do you know if the Woolies case has been appealed?
We understand that there's appeal pending, yes.
Okay, all right. And then the rest are in the chat. So I think there was There was actually one, Cilla, while you have a look at them, there was one
I'm
about.
I'm going to stop sharing because I don't want to look at my own face, if that's okay with
Okay,
everyone.
fair enough. Yeah.
Now I've got Angela and Lauren's face. There you go. Let me have a look at the chat.
Yeah.
The slide was taking up my whole screen.
There was one about the wage theft and not having suitable time and attendance systems to track time and shift penalties. Is that the most common pitfall? And only because I've been interviewing a lot of payroll people recently, I've just found in my travels that I think it's a lack of understanding of the awards in detail that has come up less. Time and attendance hasn't come up as much. It's more been around the system's not set up to deal with the complexity of the awards. That's one problem. And then there's the knowledge of the award.
Yeah, look, I think from our perspective, it's all of the above. So yes, as I mentioned, historically, HR folk knew their awards back to front, 20 years ago, 25 years ago when I started out. So we haven't had to have that granular detail because we've had the benefit of these other arrangements in place. So yes, absolutely understanding those entitlements. And I think in terms of time and attendance records, there's so many different payroll providers, there's so many different tech solutions, but there's still a real gap in terms of, are we able to sort of say, okay, well, that line is the salary, this is the overtime entitlements, this is the penalty rates, this is the allowance. We're not seeing that sophistication. So we can discharge our record keeping obligations and importantly, just refute claims. And so I think because of the salaried arrangements and the set off arrangements, many organisations, not all, but many organisations have fallen out of that really strict, rigorous approach because they haven't had to, because they had a real buffer. Whereas now what we're seeing here is if we're looking at a single pay period, you're more likely to have ups and downs. Whereas, if you've got the benefit of 6 months or a year, you're more likely to net out. And so I think we're really needing that granular detail in terms of being able to refute those claims. And, you see it all the time in underpayment claims. Some person keeps a record. We say to the employer, what do you have? And they don't have anything. So we're dealing with not only an underpayment claim we can't defend, but also breaches of the Fair Work Act in terms of our record keeping obligations as well. So it's penalty upon penalty.
And I think there was something else related to that about, do you recommend time recording for employees at all levels and salaries, or those only close to the award?
Oh, look, as people that have to actually account for their day time, I don't recommend it as a life choice if you don't need to. The billable hour and can in and of itself be a source of stress. So I think if you've got people that aren't award covered, no, but you still might have the risk coming up. If someone is not award covered, you don't have penalty rates and allowances that you need to pay them, but you do still have psychosocial risk. So they could bring a stress claim. And so I think it helps with both. But I think the closer the person is to the award, the greater the likelihood of an underpayment claim. And I think with the unions looking around for classes, you might get some employees that don't even realize that maybe they're being underpaid. You're more likely to have unions sort of stress testing that in addition to the Fair Work Ombudsman. So I do think having an ability to monitor that and to discharge those obligations is key. One would think AI provides the perfect answer, but then we've got those risks that the workplace surveillance impacts can have on the employees' well-being as well.
There was a question. Sorry, Lauren, you go. No, you go.
No, there's an AI-related question off the back of your comment there, Cilla, and it was just about AI is such a huge issue and it feels like the law cannot keep up with it. I suspect we'll always be on the back foot, particularly considering how quickly AI and tech is changing, moving and improving. So the question there is about repeating the AI statistics. So the statistic was related to dismissal-related claims in the Fair Work Commission. Now it's projected, and I didn't raise this in the actual speaking notes, but it's 50,000 is projected for the next financial year, which is excessive and higher than it's been in a very long time. The statistic on the dismissal-related claims is that 80% of general protections claims are not proceeding to court after the conciliation stage in the Fair Work Commission, which is a very large percentage of of claims that are being brought by employees following their dismissal. Yeah.
So the assumption is that people are bringing claims because they can, because AI helps them draft the claims, but they're not pursuing them because they're not actually meritorious claims or claims that have merit. And I think all of us know that people bring BS claims often. With the benefit of AI, it's much easier to do that. And we're seeing AI come up in both complaints. So it's very obvious to us if AI rather than a human has actually written a complaint. It might be a whistleblower complaint. So it's coming up. It's coming up all the time. But I agree. I mean, AI is such a great solution to so many issues, but you need to get the relevant stakeholders together. So HR needs to have a seat at the table. Together, it's not just a technology driven solution, so that we can think about all of these things and think about the people impact. But absolutely, the laws aren't keeping up with AI, nor will they ever keep up. So we just need to keep alive to the risks that it can involve.
Lauren, did you see any? We're running out of time, aren't we? So was there anything else key in there that we can quickly answer? I've lost track of it now. There's quite
a lot about time recording, keeping up with compliance.
Yeah.
On the AI, it's saying presume employers have to notify their staff if they're being tracked via AI.
Oh, yes.
So we've done a lot of advice on surveillance type technologies, which do extend a large in part to AI. So yes, and there's there's AI transparency statements coming out in the way that, for example, the Fair Work Commission is using AI. They've expressly said that it's not for decisions, but that they're using it in other ways. So it's being dealt with within organisations, but also within the regulators and the other structures in which we're operating. So it's coming up all over the place, particularly around surveillance and notice. Yeah.
Yeah, but essentially, it absolutely is triggering workplace surveillance laws that exist state by state. And then, as we said, that psychosocial wellbeing, work health and safety lens as well. How do you juggle those competing interests?
Yeah.
All right, I think we've got to let you go, don't we, Cilla and Lauren? You've got another meeting. So thank you again for an amazing session. That was very interesting. So look, we always manage to get so much in. So thank you really so much for your expert knowledge. We hope this has been useful for everyone, and please do reach out to Cilla if your organisation or you need some help with any of these sort of related issues. I can see everyone saying thank you in the chat, so I can see that.
Awesome.
Thank you.
Thanks everybody.
And enjoy the rest of your day wherever you may be. Thanks, Cilla.
Cool.
Thanks, Lauren.
Thanks a lot. See ya.
Thanks, everyone.
Thanks.
Bye.
Bye.